Hi, Zachary C. Ashby at Pacific Northwest Family Law. When it comes to divorce, one complex issue that we've dealt with is when one spouse is either anticipating moving or already lives in a different state. Living in different states is not an insurmountable obstacle. One of the first questions that comes up when spouses live in different states is, where do you file? Am I going to file in Washington or Florida? One of the big considerations that I usually go through without comparing the different potential results is, where's the property located and where did the spouses most recently live? In Washington or any state, you can usually file a divorce in the state where you live, but the court is going to have limited ability to divide property that's in a different state. For example, if you own a house in Washington, it's going to be a lot easier to get a division of the house and determine property rights if you file in Washington. Some other considerations is that in general, Washington courts are a little bit easier when it comes to spousal maintenance. It has the purpose of getting the other spouse into the workforce and earning about the same or maximizing at the very least their income potential. Whereas other states may take a different approach where there are calculations and formula based on the amount of time you live together and the income, how much alimony is going to be, regardless of whether the spouse is entering the workforce or not. So Washington State is also pretty good when it comes to residential time or child custody, meaning that the courts have had a shift recently by and large to treat both parents equally when it comes to residential time with their kids. And really, that's another question when it comes to parents living in different states is, how do you create a parenting plan? Because you're going to need to figure out a schedule where both parents are able to raise and nurture the kids to the extent that they're able. We call these long distance parenting plans, and oftentimes it may include the children living with one parent for the school year and then living the majority of the summer with the other parent. But your circumstances may be different, so that parenting plan wouldn't necessarily make sense. So that is something that you would want to get some professional help with to see what exact parenting plan is going to make sense for a long distance relationship. Now, if it so happens that during the course of a divorce, one spouse wants to move out of state, either to be near family or get a job, that's still possible for that spouse to do. However, if children are involved, it becomes a little more complicated because the court takes interest where children lives, and you have to ask permission to relocate the children to another state with that spouse, and it's going to affect the parenting plan. Some reasons to be able to move are going to be fewer connections in Washington, fewer opportunities for the children and for the spouse, and in general, that moving is going to be in the children's best interest. Some things that push it in that best interest category are going to be, in the new state, there's going to be equal or better educational opportunities, medical, or a closer family to help support and raise the children. So there's actually a list of factors for relocation that you should go over with an attorney to make your case very solid to be able to move to another state. One word of caution: if you're in the midst of a divorce, one of the defenses or accusations that are going to be raised to relocating with the children is the purpose of the relocation is specifically to remove the children from the spouse who's not relocating's care. So that's a consideration too. Now, some other things when it comes to child support, no problem establishing that in Washington, and even having the Division of Child Support enforce any child support orders, or using the Washington courts to enforce those orders, because that's a simple thing to be able to do. Other considerations are going to be whether or not the court has the power to order the spouse who lives in a different state to do things like pay alimony or attorney's fees, or otherwise do any other kind of things that, if both of you are living in Washington, the court would have no problem ordering. This is a question of jurisdiction and connections with Washington State. If your spouse recently lived in Washington State with you in a marriage, likelihood is that the court will be able to have personal jurisdiction over them, even if they've moved. Now, if they lived in a different state for a longer period of time, or if they've never lived in Washington and have no connections, the ability of the court to make those kind of orders is going to be reduced, and you'll need to consider whether that's going to be a factor in where you're going to file. These are all very technical and very specific questions. You'll probably need to consult an attorney if this is something that you're facing, to make sure that you're able to get not just the orders you want in court, but to make sure that you're able to get those orders enforced going forward, and that you're able to finish your divorce or other family law matter and have it be unchallenged so that you can start again. I hope this information was helpful. If it was, please subscribe to the channel. If you have other questions, please comment below. Try and respond. And if it's a particularly good question that has a longer answer, may do a video just for you. Yeah, please like, share, subscribe. Thanks.